Hey guys, it's Cam here and wanted to give you an update on the May 7th court hearing, which occurred a couple days ago at 2 p.m. Already there have been a couple orders issued by Judge Glenn, so it's actually not a bad time to get into the details. And before we jump in, I just wanted to clarify that I'm speaking in my own personal capacity. I'm not representing the LOC here, and I can only speak to things that are in the public domain. So there are going to be some things that might be confidential when you're part of an inherently litigious organization. You can't be divulging secrets or compromising the integrity of that organization. That's something that I'm taking seriously, but I am free to talk about things that are in the public domain. So let's jump into it. We had distribution updates. Then we got into the Stretto data security incident, which has paused distributions. Then a pro se creditor, Voelker, who is an investor in iShares, was looking to get the in-kind claim amount returned to him via iShares. Keith Noyes, formerly of the UCC, was looking to be cleared of having acted in an ultra-virus manner in order for him to join the Litigation Oversight Committee. And there was a process for beneficiaries of deceased account holders to recover their distributions. If we jump into the slides here, we can see the current state of affairs, and this is more easy to see in the red line version. So you can see here, they told us where we were before and where we are now. And I have a version of this here. So previously, the domestic distributions through PayPal and Venmo, they have increased $150 million from $1.2 billion to $1.35 billion. So that's up to 93% from 86%. The international distributions through Coinbase are up $70 million, and this would also include domestic distributions that failed to go through PayPal and Venmo. So this is up from $747 million to $817 million. And then the USD distributions, which are occurring through Stretto, mostly through wire or check, those are up $47 million. And they were previously at 18% completed and are now at 46% completed. So a big uptick there, although there are some issues. Some creditors have been reporting that checks have been bouncing, which is seriously cause for alarm. And let's hope that the wind down estate gets that taken care of. Now, there's one issue here. The overall numbers said it was up $240 million, but these component pieces add up to $267 million. So there is some number fudging that occurred here, but it should give us at least a ballpark of roughly where we are. It could be that one of the people putting the slide together just made a bit of an error. So can't have absolute confidence in these numbers because they don't quite reconcile. So we got some information about what happened with the Stretto leak. We had Chris Koenig handed off to a lawyer for Stretto representing McDonald Hopkins, an outside counsel. And this lawyer, Joseph McNeils, was seemingly on vacation in South Carolina at the time. He's based out of Philadelphia. Judge Glenn was not happy and effectively summoned Joseph McNeils from his home in Philadelphia, which he presumably will be returning to next week, to the courthouse in the Southern District of New York in person. So he will have to appear at 3 p.m. on Tuesday, and it will just be about this Stretto leak, presumably. So we will get an update on that. But we did get information about what transpired, and I have a helpful diagram here which can walk us through it. So this apparently, what occurred was a Stretto employee, represented by this figure here on the left, received a text message from a threat actor, which is just a euphemism for the person hacking the system here. So this person texted the Stretto employee something, which this obviously is not the exact text message, but he solicited the credentials of this employee. And this employee apparently was not well trained and replied via email with his credentials to the Stretto system. So that's a big mess up. But now the attacker has the credentials for how to access Stretto systems. So the first thing this guy does is he logs in to the email account of the employee. And he pokes around, presumably, and looks for ways he could exploit this information. He logs into Stretto's Amazon Web Services account and does surveillance there so they can see that he was poking around to see what types of services that Stretto was using and provisioning within AWS. And then, more concerning, he logs in to this Stretto core application, which is an internal software application that services claims for their clients. And this employee apparently had access to look at personally identifying information from us Celsius creditors. And this included our names, email addresses, mailing addresses, and claim amounts. Now, some of this has already been published on the docket, including our names and our claim amounts. But the email addresses and mailing addresses is new, and obviously that's not good. So additional 40 or so, maybe a little less, creditors had their tax IDs accessed, and that's obviously significantly more concerning. So if you were notified by Stretto that your tax IDs were leaked, you may want to get your credit reports run and monitor those to make sure that you aren't having new lines of credit opened in your name or things like that. But importantly, claim codes were not compromised. Stretto and Celsius were concerned that the attacker might have gotten access to claim codes, which would have enabled them to log into PayPal and Venmo and actually hijack distributions that creditors are entitled to. And that would be a horrible situation. Imagine waiting 2 years for your distribution and then having it stolen. So they paused distributions and have apparently reached the conclusion that claim codes were safe. The employee never had access to those claim codes. So even though their account was compromised, the claim codes could not have been accessed. So because of that conclusion they've reached, I'm anticipating the distributions will be re-enabled sometime next week, potentially around the time of the Tuesday hearing. It might be motivated because Judge Glenn literally ripped this lawyer apart, pointed out that this should be his highest priority, how raking over the coals about how creditors deserve to be notified that their information was leaked. So he will probably want to have some good news for Tuesday that distributions had been reactivated. So that's just my expectation. There have been no promises of when these will be reactivated. But if I had to guess, next week seems a very likely time frame. So here's the incident timeline as revealed in court by Joseph McNeilus. On April 16th, a smishing attack, which apparently is the term for a phishing attack that occurs over SMS. This smishing attack occurs where a employee gets the text message saying, hey, give me your credentials, and he decides to just email them off because is this the most gullible person ever? Who knows? But they give their credentials to the attacker. The guy's rooting around through AWS and Stretto Core, and that occurs on April 16th. Stretto discovers the breach the next day on the 17th and locks down the compromised account and kicks off their internal investigation. Celsius seems to be notified on April 23rd based upon when they filed information on the docket a few days later. So they claim that they were notified April 23rd. Why did it take a week to notify Celsius? It's a bit concerning, but who knows? So we have this on the docket, ECF 4834, notifying us of the data security incident. Judge Glenn pointed out that not all creditors, or to be honest, not very many creditors are looking at the docket, so this was not sufficient to notify us of this problem. By May 2nd, McNeilus said that they had figured out whose information had been compromised. And then on May 7th, the counsel for Stretto, Joseph McNeilus, gets reamed by Judge Glenn for providing these updates without a sense of urgency. And then later that day, emailed account holders to let us know of the leak. That email was likely because of how upset Judge Glenn was towards the Stretto counsel. So this is not new information. This occurred some time ago, but the emails were dashed off because of how unhappy the judge was. So the report on the incident is due on the 9th, which is the day that this is being recorded. It will probably be published on Friday. So happy Friday to all you out there. And then we have a follow-up hearing on May 14th. Next up, we had an adversary proceeding by Mr. Voelker, who is a shareholder of iShares, which was a customer of Celsius. And the claim here by Mr. Voelker is that because iShares was a Wyoming corporation, that they have some sort of perfected security interest and would be secured creditors and would be able to get their crypto in kind back, which the judge has now issued a ruling saying, no, not the case. You are within the bankruptcy estate and just has denied this claim here. It really was denied for a few reasons. It was untimely. So we have largely received our distributions at this point, so it's a little bit late to be objecting to things through the plan that has been confirmed and already, like literally iShares actually received an initial distribution themselves. So this is very late. And there just didn't seem to be a really strong basis for this. And to compound the problem, iShares never returned a ballot, which meant that they were automatically opted into the 5% class claim, which means that they are barred from bringing these other matters. So if they had opted out of the class claim, they would have had better standing to bring this adversary proceeding. So they didn't really stick up for their rights, which is unfortunate for them, but it made it relatively trivial to rule against this claim here. Now, there were some interesting things in the filing. They claim, or Voelker claims, so Voelker was able to get the right to argue on iShares' behalf. So he basically took over, apparently, the legal right to advocate for iShares as a shareholder in that company. So there was a legal proceeding for him to get that basis. And his claim was that it took me this long, so I shouldn't be denied my rights because of being eventually appointed through this long process. But unfortunately for him, iShares did not assert its rights. So even though you can represent iShares, they have now opted into the class claim. But they did argue that they had 17.6 Bitcoin within Celsius. But if you look at their claim, and this was as loan collateral, if you look at their claim, they have only 1.17 Bitcoin. And this is a really big discrepancy. And one thing that is interesting here is this number. If we take these digits here, they actually line up perfectly with the claim amount, right? So it's a really big question. Why do these numbers line up so well? If they only have 1.176116, we'll call it 3 Bitcoin if you round up here, how could it be that the amount that they claim to have is 17.6? Like, these numbers are identical except for the fact that this is 17.6 and this is 1.176. So something is very odd here. And my theory is, and this is just a personal theory, is that something screwy has gone on the iShares part, where they're representing to their shareholders that they had 17.6 Bitcoin when they actually had 1.176 Bitcoin. Now, the error is either with Celsius or with iShares. And my thinking is it's with iShares because they have a $17,000 loan at just below 9% APY that was taken out in June of 2021. And at that time, Bitcoin was trading at about $35,000. Now, what that would imply is that the $17,000 loan would be about a 40% LTV on 1.17 Bitcoin, which is a pretty reasonable LTV to take out. But it would be only a 2.7 LTV on 17.6 Bitcoin, which would be remarkably low. And at 9%, it doesn't seem like that would be particularly reasonable. Like, to have such a small loan to value would be very odd. So that leads me to speculate that somehow, this 1.17 is correct on the Celsius books, and something strange is going on with iShares and their investors. So if I was an investor in iShares, I would be asking questions about what happened with this loan collateral. It could be that there's something else afoot. But again, this is all just speculation based on the information in the public domain. And the matter is closed as far as the court is concerned, the bankruptcy court. But there may be other issues that Mr. Voelker needs to take up with the company that he had apparently invested in. Next up was Keith Noyes in a pro se capacity, looking to be cleared of having acted in an ultra-vires manner while he was a member of the UCC. As some background, Keith was a risk management employee at Coverio AG, which is based in Switzerland, and he was representing them on the UCC, chosen as one of the 7 committee members by the U.S. trustee. And the trustee has absolute authority to appoint and remove members of the UCC. Now, Coverio faced financial difficulties after the Celsius collapse and filed for bankruptcy themselves in a Swiss bankruptcy court at the end of 2022. This matter was never really addressed, so the trustee has the right to remove that position, and Coverio had the ability to reassign the representative to somebody else. They never did that. So Keith continued to serve throughout the rest of the year 2023, at least the majority of that year. And then when he was appointed to the LOC, elected by the UCC, which had the right to appoint members to Litigation Oversight Committee, the trustee then raised her hand, seemingly suggesting that because Coverio was no longer a going concern, he was not appropriate for either being upon the UCC or the LOC. And the ultra-vires accusation means that he would be acting beyond his authority. I'm not a lawyer, and that term is something relatively new to me, but acting beyond one's authority is the meaning of such a term. So the trustee removed Coverio from the UCC and forced the rescinding of Keith's appointment to the LOC. And the LOC had an empty 7th seat. That spot has since been filled by Pamela Corey. So that announcement was on the docket. And the trustee, now that the seat is filled, no longer is asserting that Keith acted in an ultra-vires manner. They feel like the matter is moot. They only raised it because they didn't feel it was appropriate for him to be appointed. The committee came to Keith's defense, laying out why he had not acted in an ultra-vires manner. The details were that the trustee had been notified that Coverio was in bankruptcy back in December of 2022. Both the U.S. trustee and the UCC had reached out to the Swiss bankruptcy administrator of the Coverio estate, and they didn't receive any instructions about what to do with their UCC appointment. So the argument is that Keith was behaving appropriately. He was never instructed that he had to step down as Coverio's representative, and there's no reason for us as creditors to doubt that he behaved in any manner other than as a good contributing member to the UCC. In his statement, Keith said that he devoted the most amount of time to the UCC of all the members other than the 2 co-chairs. So by all accounts, he devoted a lot of energy advocating on behalf of creditors. And I know the UCC hasn't been the most popular amongst creditors. And I think, a lot of that comes down to communication. If they had communicated more with creditors, I think they would have been appreciated more. If you look at their accomplishments, getting the crypto distributions was actually a really big win that other crypto bankruptcy estates have not pulled off. The UCC also, through White and Case, drafted great complaints against Celsius insiders. And those are complaints that the LOC, through the litigation trust, will be picking up and running with. So good on you for that. We need to hold these insiders accountable. I was among creditors that wanted Celsius to be shut down as a financial institution that lost billions of dollars. My own personal belief is that you don't get a second chance at life. You've violated your reason to exist, so I would have preferred it being shut down. But they felt like they could get more value on our behalf by spinning off a new company and trying to build value around the mining assets that, over $700 million of funds had been plowed into. We can all hold out hope that NASDAQ listing is coming soon. Lastly, in court, there was an unopposed motion for the procedures for beneficiaries of deceased account holders to receive distributions. And effectively, that process would be if you are the beneficiary of somebody who passed away who is owed a Celsius distribution, you would have to pass KYC yourself. You'd have to demonstrate that the person on whose behalf you're claiming a distribution for, that they actually have passed away. And you would have to show that you are the beneficiary. And then there would be a period, basically a waiting period for people to be able to object to that in case there's some sort of estate issues where somebody else feels like they have the claim. So there would be some sort of waiting period, and eventually you would get your distribution. So it'll take time and probably not a very fun process, but that has been laid out and approved by the court. So again, we have the next hearing on May 14th, where the Stretto outside counsel will have to answer again for the Stretto security incident, and hopefully distributions will be turned back on right around then. Until then, have a wonderful weekend and happy Mother's Day to all you and your moms. Talk soon. Bye.